So restrictive covenants are provisions that many employers in New Jersey and other states require to protect themselves from having spent money training an employee, giving the employee customer lists and the like. And then after they have that investment in an employee, they don't want the employee to leave, take the customers with them, and harm the business. So restrictive covenants have been around forever, although there has been a big push recently to do away with them. The FTC, about a year and a half ago, tried to do away with all of them and ultimately were not successful because the courts found they didn't have the authority to do that. And in fact, just yesterday, the FTC finally gave up on that endeavor completely. And so for the moment, restrictive covenants are still alive. They are generally enforceable if they're reasonable. And by reasonable, I mean how long the restriction is for. In New Jersey, a restrictive covenant generally that's a year or even 2 years is usually found to be reasonable. It needs to have a reasonable geographic scope. For example, if you say that you can't compete with us within 500 miles, a court will say that's far too broad. It's not protecting your clients and your customers, and will strike it down. But if it is reasonable and has a reasonable duration, courts will enforce them unless they impose an undue burden on the employee. And in terms of this undue burden, where we received the decision on August 29th, where a medical group terminated a member of the group. They had the right to terminate without cause under the contract. They also had the right to terminate for cause. And the issue became at the trial whether or not they really let this person go for cause or without cause, because that issue is relevant to the issue of undue burden. And if a restrictive covenant is burdensome on an employee, that's not sufficient to strike it down. The case law says it needs to be an undue burden. And by that, the court usually means if the employee brought the restriction down upon himself by either not doing a good job or being terminated for a variety of reasons that would justify a for cause termination, the court will likely find that the restrictive covenant under those circumstances is not unduly burdensome. In this litigation that we had, the medical group terminated our client under the contract without cause, which therefore likely may have caused the court not to enforce the restrictive covenant. Yet at trial, they said they only did that because they didn't want to hurt the employee in terms of him looking for another job. Yet at the trial, they claimed that they really did let him go for cause, and they marched up 7 of his partners, other doctors, who said very, very disparaging things about our client to try to show that he was the one that essentially caused his own termination, and therefore the restrictive covenant should be enforced against him. And the court focused on that because there are various elements one needs to establish to enforce a restrictive covenant. You have to show there's a legitimate protectable interest. Here, they were claiming that he was still working at the same hospital he worked at when he was an employee, and that they were losing patients who were following this doctor rather than remaining at the medical group. So We argued, though, that they were really getting out of the pediatric neurosurgery business, which is all that our client does, and therefore they did not have a legitimate interest in restraining him. And the court was on the fence on that one because he was replaced by another doctor who frankly dabbles in pediatric neurosurgery. So the court indicated in its decision that they did establish a legitimate interest, but barely so. And that's one of the factors you look at when enforcing a restrictive covenant. The bigger issue was, did he bring this upon himself? And therefore, while the restrictive covenant, which precluded him from working at this hospital, did that impose a burden on him where he could still work elsewhere? Or was he really let go due to his performance problems, alleged performance problems, and therefore the court would feel he brought it upon himself, and therefore it's not unduly burdensome. So a good portion of this trial, which lasted 16 trial days, I would estimate more than half of that time was spent by people testifying about what he allegedly did, which gave them cause to get rid of him, and therefore the non-compete should be enforced. We proved during the trial through our witnesses and cross-examination of their witnesses that their reasons that they were giving for getting rid of him were untrue. The court found that the 7 doctors or 6 doctors they called as witnesses, none of them were credible about their issues, alleged issues with him. And the court found, which was our position, that they did not get rid of him due to anything that he did. They got rid of him because there were financial issues at the practice. The pediatric neurosurgery business we established really was not a profit center for them. And so they got rid of him for their own reasons, and therefore it would be an undue burden for him to have to abide by the restrictive covenant. And that's ultimately what the court held, that he was a great doctor. There was not one piece of paper leading up to his termination where anyone complained about his skills as a physician, his demeanor, his interactions with employees, and the court therefore concluded that he did not bring this upon himself. It was an undue burden because the interesting part of the case was that our client specializes in such a niche area that Hackensack University Medical Center is really the only hospital in New Jersey that offers all of the panoply of services that he was performing. And therefore, he really couldn't take his expertise, go somewhere outside of the geographic area where he is allowed to work. And those hospitals did not have the infrastructure that would enable him to do that type of very complicated surgery on neonatals and pediatric neurosurgery, because there's a lot that goes into that type of a surgery. You need pediatric anesthesiologists, you need a very well-trained neonatal intensive care unit, et cetera. And Hackensack was really the only place he could do that. In fact, he received a lot of patients from being transferred from other hospitals. And therefore, our argument was, if you bar our client from working at Hackensack, he would not really be able to make use of his talents and be able to perform these other types of very important and complicated surgeries, because the other hospitals in New Jersey did not do that type of work, didn't have the other doctors that would be needed to support him for those procedures. So we did argue that if the court restrained our client from working in Hackensack, he would be unable to use his particular expertise, and therefore enforcing the restrictive covenant would harm the public. And one of the elements that is considered by a court, whether to enforce a restrictive covenant or not, they always take into consideration the public interest. And we, I think, made a very compelling case that if our client was precluded from working at Hackensack, the types of work that he was getting, like with the children who were transferred from Newark Beth Israel, or other types of surgeries on neonatal kids, kids a few months old who were born prematurely and may weigh 3, 4, 5 pounds. Other hospitals were not doing the operations on such young and premature children. And our argument was to the judge, if you bar him from working at Hackensack as a result of the restrictive covenant, the public would be harmed because they would have nowhere to go in New Jersey and would likely have to either travel to out-of-state hospitals to have these procedures done. And that's a factor that a court looks at when deciding to enforce or not enforce a restrictive covenant. Here, though, the judge, because he found that our client was really let go without cause, and it would be an undue burden on him if he enforced the restrictive covenant, the Chancery judge in Bergen County did not even get to the public interest piece, because once you find that enforcing a restrictive covenant would be an undue burden, that's where the court will stop its analysis and decide that I cannot enforce the restrictive covenant for that precise reason. So here, the court could have gone to the next step and found not only is it an undue burden, but it would harm the public. But the court, I believe, although the judge didn't indicate this as the reason, but the court stopped its analysis once it found that if it enforced the non-compete, it would in fact impose an undue burden on him. So these cases are very fact specific, and it's difficult at the outset of a case to know how all of these issues ultimately will play out, but there is no cookie cutter way of looking at these cases because each employee's background and talents are different. The ability to do their work elsewhere is always an issue. Courts look at whether or not, if the court imposes a restrictive covenant, whether the employee will be able to get work elsewhere and earn a living, because courts don't like to restrain someone if that precludes them from earning money, supporting their family, et cetera. So the reason the facts are different in that regard, or sometimes you get an employee who has a restrictive covenant who has only worked in the same industry his whole career. And if the restrictive covenant is to keep him out of the industry for a period of time, he's not going to be able to get another job or a job that pays him hopefully comparably to what he was earning in the industry, because he has no background and no experience in the industry. So that's another big issue that often comes up in these cases, is how experienced the person is, what other types of work they can get. And the reason I'm mentioning all this is the same applies when you represent an employer that wants to impose a restrictive covenant. how it gets imposed and what the terms are need to be modified often based on the circumstances. And therefore, an employer really should have an attorney design and draft the restrictive covenant to meet the particular issues of the situation. You do need to know about the employee's background. You need to know where else they've worked. Um, you need to understand the law in the state that you're dealing with, because every state, and this is usually a state by state issue, because the case law about what types of restrictive covenants are enforceable is determined by precedent, cases that have come up in the past. This is not a statute. There are no hard and fast rules. There are general propositions like 1 year may be reasonable or 2 year term may be reasonable. A 5 mile radius where they can't work may be reasonable, but all of that needs to be analyzed to, at least from the employer's point of view, to ensure that when a court looks at it to decide whether to enforce the restrictive covenant, is looking at it from the lens of what the prior case law has said and making it reasonable that you're likely to get it enforced by the court. But the other factor that comes into this from the court, which I should mention, is a doctrine called blue penciling an agreement. Courts will generally blue pencil it or cross out, for example, a 2 year restrictive covenant and make it 1 year if the court feels 2 years is too broad. Geographically, the court can narrow it so that it fits within the law. However, there's still case law that says if the document, the clause is so offensive, the court has the right, instead of blue penciling it and making it more reasonable, the court can conclude that the employer went too far here and is just going to rip up the agreement and not enforce it at all. So an employer really needs to know from their attorney what is reasonable, what's likely to be enforced, and it needs to be drafted appropriately. The other problem is from the employee's point of view, especially in the healthcare field. Doctors who are coming out of medical school or out of their residency, I find from having represented many, many doctors over the years in restrictive covenant cases, seem to come to me with the first question or their first statement is, I always thought these were not enforceable. And I have to tell them that that's not true, that if they are reasonable and depending on what state you live in, they can be enforceable. So doctors who were given out of med school or out of their residency or their fellowship, their first employment contract, and they see that it has a restrictive covenant, they really should seek counsel to go over the contract for them, because more often than not, they feel that they don't have any bargaining power. They sign the agreement, they don't negotiate the restrictive covenant, and then when they go to leave 3, 4, 5 years later, where they're not made a shareholder and they have to leave, that they then face this restrictive covenant, and it can really screw up their ability to continue to perform their medical services in their field, in the hospital, or in the region where they've developed a name. And if they're forced to sit out of that industry in that area for a year or 2 years, whatever following they had are likely to have gone elsewhere and not come back. So both the employer and the employee really needs to look at these restrictive covenants and decide, are they fair? And the only way they're really able to do that, in my opinion, is if they go to someone who's experienced in negotiating these agreements, who are experienced in trying these cases and knowing what a court or a jury might do under the circumstances.